Thanks, Marcia. As Marcia said, my name is Maddie Bell. I'm an associate attorney here at Cavitch, and I'm here with Max Dane, who's a partner at Cavitch. And we're litigators, and a fair amount of the work we do is employment litigation. So sexual harassment is the topic today, really cheery topic for Thursday afternoon, but it's something that we deal with quite often, and it poses a big risk to businesses. So let's talk a little bit about some of those risks, first of all. So risk to operations. Sexual harassment issues are disruptive. Whether it's a lawsuit, whether it's an OC, which is an Ohio Civil Rights Commission, or EEOC charge, it's disruptive. It costs money and it costs time. How does it disrupt your operations? It disrupts working relationships within your operations. So you have an alleged harasser and a victim, or maybe multiple victims. Obviously, the relationship between those individuals is going to be impacted. The relationships with your company is going to be impacted. The harasser or the alleged harasser is going to maybe feel targeted if he doesn't feel that he's been appropriately called out, he or she. The victim is going to feel a lot of emotions and potentially some disrespect. So anytime you have that dynamic in working relationships, productivity dips. So it's also going to disrupt productivity. Those that are involved in the allegations are not going to be producing like they normally do. They're going to be going through a lot of things emotionally, and they may even be on leave. You may not be utilizing them as employees. And that obviously impacts productivity if you have employees out of the workforce. Additionally, with productivity, and Max and I talk about this often, is the impact on your company's culture. And company's culture is huge right now. You see companies splashed across, Fox 8 or, any type of news outlet for having a hostile work culture. And to have productivity be at its highest, you really need to have a good culture. People need to enjoy coming to work. They need to feel safe at work. So if there's a bunch of issues of sexual harassment floating around your workplace, that's really going to negatively impact how safe people feel at work, and ultimately your overall culture and how you're perceived by outsiders. Max said when we were discussing this presentation the other day, if someone's worried about asking a coworker out on a date, they're not focused on work. If somebody is telling a dirty joke to a coworker in the lunchroom, they're not out there working. So that is really impacting your productivity and your culture. Additional risks is the risk of litigation or an OCRC or EEOC charge. So time costs and money costs are what we look at with the risk of litigation. Max is going to get into a little bit later, what does the legal process look like from start to finish, from answer to trial. But I'll tell you, and Max, you tell me what your experience is too, especially with COVID, you're looking at least 2 years of litigation unless the matter settles. Do you think that's accurate?
Yeah, I think it's fair. And I would just jump in to kind of add on to what you've just shared, Maddie, is that first of all, our primary focus, I think, as lawyers, and probably most counselors would feel similarly, is to keep you out of litigation. I mean, we're lawyers, we try cases, we're trained to try cases. That's what we do. But a good part of our work is focused on keeping clients out of court. Because as Maddie just said, particularly with sexual harassment, when you start measuring time, you start measuring money, you start measuring the impact on, as Maddie described it, the culture of the workplace and the impact on your primary business focus, which is to be productive and to generate profits and to employ people and to generally run and operate a successful business. I think sexual harassment lawsuits may be the most expensive by all those measurements, legal problems that a business can run into. So a big part of what we do is try to keep folks out of that mess.
And with regard to it being the most expensive, one thing that I was going to mention, Max and I were recently in a mediation where we settled a matter for $159,000, and that was in settlement. They had exposure of probably
A lot.
$600,000 if we would have gone to trial.
Yeah.
So when we're saying it's costly, we're not lying there. You know, that this was a settlement of 159, not a jury award, a settlement. So it's definitely one of the most costly issues we see in practice. So what's the impact of harassment? What happens when these risks come to fruition? Financial, we just went through, you know, the recent sexual harassment issue that Max and I dealt with and kind of the financial impacts of that on that entity. But there's other financial costs besides just litigation value. One, you're going to want to get your folks trained. Sometimes a court can order that you have your folks trained, which costs money. It's a good thing that you guys are all here today, because you're kind of taking that first step in getting this training, and that's always one thing that we tell clients is so important with sexual harassment. One thing that we see asked often at depositions is, when was the last time you underwent a sexual harassment training where you educated your folks on sexual harassment? So it's a good thing that you are all here today. You also have the loss of productivity, which takes a financial toll on your organization that we discussed. Potential loss of employees. They may be out on leave. It may result in somebody getting terminated or more than one person getting terminated. It may result in somebody feeling unsafe at work and resigning. So loss of employees, that's definitely going to impact your company financially because you put training into that employee to get them up to par. So any loss is obviously an issue. And PR and marketing issues. In today's day and age, everything is on social media. Everything is in the media. So there may be some issues that you need to deal with publicly that is going to cost the company money.
Can I just jump in, Maddie, just to make clear that particular point?
Mm-hmm.
And it's a really difficult and sometimes almost tragic perspective on these things. What Maddie's trying to say is that individuals, I don't mean you're trying to say it, when a business gets sued for sexual harassment, that's public.
Mm-hmm.
And men and women who may be married, who may have families, who are deeply invested in their reputations, as well as in the operation of the business, may be named. And that is a really, really difficult, not only cost with respect to the business, with respect to that individual, but I've seen it impact families. It's real, and it's something that we try to account for.
And that's kind of a good segue into the emotional and personal impact of harassment. So for those involved, both the harasser and the victim, there's significant issues. I mean, we've seen people get divorced over issues of workplace sexual harassment. Even somebody who's a victim could impact their relationship. Folks may need to undergo therapy, take time off to recover if the sexual harassment is traumatic to them. And it can be emotional for coworkers as well as other individuals that are working for your company. If they see that somebody is going through this type of issue, one of their coworkers that they care about, it may cause them emotional distress. With regard to kind of the functional and professional impacts, so the functional kind of goes to what type of culture do you want to have at your company? How do you want to be perceived by the public? How do you want to be perceived by those that work for you? Is this a safe place to work? Is this a discrimination-free place to work? And professionally, if you're on a bunch of public dockets being named in sexual harassment lawsuits, it's going to impact your reputation professionally. It's also going to impact the reputation of those involved in the sexual harassment. The harasser, that person's professional career is going to be significantly impacted, as well as the individual who was harassed. We've seen folks resign. We've seen it significantly impact whether or not they're willing to come back into a professional role and whether or not they're able to.
It can have an absolutely catastrophic effect on people's careers. I just wanted to kind of say in kind of summary of what Maddie just shared with respect to this slide and these comments is that we kind of almost approach harassment as a disease. It's something that we work to avoid, to help keep a business healthy. And it's something that when it arises, we work to cure it promptly and appropriately in order to make a fast and clean healing process possible. So go ahead, Maddie.
And one other thing kind of to play off that, a lot of what we do is counsel companies on, day-to-day issues that arise that haven't resulted in litigation yet, and maybe never do. It's really important for companies to have trusted people to discuss sexual harassment issues with, because they are so toxic. If you don't deal with them appropriately right away, and we'll get into conducting thorough investigations and safe reporting, but if you're not doing those things, that's when it results in litigation. So as Max said, obviously our job is to help companies also avoid litigation and deal with litigation when it arises. So speaking of affecting folks' careers, Max is going to talk a little bit about the prominence of sexual harassment issues today and the Me Too movement.
Well, just thinking about it as a lawyer, obviously there's a much higher awareness of sexual harassment and sexual harassment in the workplace, and that results in more legal problems. I think generally employees, the public at large, take a more expansive view of what constitutes sexual harassment. And let's be clear, we're talking about conduct, and we'll get into the specifics, but conduct that is illegal and actionable. That is, you can get sued for it. I think there's a more expansive view of what constitutes harassment today. I think, conduct that 30 years ago would have perhaps flown under the radar or been viewed as acceptable is no longer acceptable. I think that there's obviously a much higher sensitivity to the issue, and people are more easily triggered. That is, people more easily feel that they've been mistreated and that they are going to look for help. And finally, the legal community has a far more acute awareness of this issue. Let me just cut to it. There's a lot of plaintiffs' lawyers out there who will make a lot of money suing businesses on behalf of employees who think that they've been harassed. Maddie and I can work really hard and make a decent living and take care of our families. But if you want to be rich, you might want to go into the plaintiff's representation business because those folks are out there making a killing. There's a lot of suing to be done. And again, it's our job to keep businesses out of harm's way. And if it happens, maybe jump in and be helpful with respect to litigation. But there is a lot of incentive, economic incentive for people to bring these lawsuits. So we put together some kind of high profile images just as kind of a touchstone to kind of talk about this a little bit. You see the new quarterback of the Cleveland Browns, and we don't know if Deshaun Watson did anything wrong or not, but we're all familiar with the allegations. And the allegations give rise to, one kind of particular form of a seemingly personality trait that we see involved in misconduct in the workplace. An extremely talented person. Now, again, the allegations with respect to this individual are that he was active with at least 22 purported victims. This is a guy who, if all this were true, may suffer from an addiction. Again, a super talented guy. And maybe, again, if the allegations are true, acting so selfishly, you would almost call that kind of conduct sociopathic. Let me back up a second. We're not showing you pictures of famous people just so we can have sort of a generalized conversation about society and sexual harassment. These personality types and this kind of conduct arise in the workplace. Maddie and I have both dealt with real world, either counseling or actual lawsuit situations in which this sort of behavior became an actionable issue and impacted the life of a business or life of people who are either accused of this conduct or suffered from it. So again, just to leave Mr. Watson alone for a minute, there's kind of three characteristics that permeate this conduct. I think immaturity, kind of a loss of judgment, and then finally, oftentimes tragic consequences. So let's pick on Matt Lauer for a minute. Now, we're pretty sure that Matt Lauer actually had some misconduct that seems to have been demonstrably attributed to him. And here we have a guy who fits into the category of protected star. He earns the company a lot of money. He's kind of above criticism, and he may be a charismatic guy who's attractive to folks who work for him. I guess what we see again in a more common workplace scenario is this type of personality who has a certain sense of entitlement and who is kind of running outside the rules, and who really is able to flourish and when I say flourish, I mean in kind of a negative sense, and do a lot of harm. Now, Mr. Weinstein, to your far right, I think has also, I don't know what's confirmed and what's not, but it's certainly been alleged, incredibly alleged, that Mr. Weinstein engaged in inappropriate behavior with folks who wanted to establish a successful career in the movies. And this is, Maddie's going to talk about this later, but he kind of represents a course of conduct that we call quid pro quo. You do this and you get that. Again, that's not, he's the gatekeeper. He's a guy who stands between the employee and that place that the employee desires to get with respect to their own careers. We just finished, well, not long ago, we finished up a situation involving a senior executive who had an assistant who he struck up a relationship with. And it was kind of that similar concern that there's a quid pro quo in place. This guy defined the contours of this young woman's career. And the fact that he had a relationship with her, and Maddie will talk about more of the kind of the technical perspective on this quid pro quo question, but it's beyond question that he would have a defining impact on her career. So when they find themselves in an intimate relationship, that question arises: did she do this in order to, or because he made it clear that it would be good for her career? And trying to break that down financially, that costs hundreds and hundreds and hundreds of thousands of dollars for this business to resolve. And it cost that individual his career. It cost him an ownership stake in a very successful business. And tragically, it cost him his family because he was shortly thereafter embroiled in an ugly divorce. So we're not trying to be overly dramatic here, but this stuff is real and it arises frequently in the course of our practice. Maddie, do you want to introduce the next slide?
So you've heard a lot about, actionable conduct. What constitutes actionable conduct? And now Max is going to talk a little bit about Title VII, which is a federal statute, as well as the Ohio statute 4112 that defines what is actionable.
So Title VII is a federal anti-discrimination law. It's really an historic piece of legislation. It goes back to the early 1960s. I believe it was during the presidency of Lyndon Johnson. I'm almost sure that's true. Probably 1963 or 1964. In any event, Title VII makes it illegal to discriminate against employees in the course of operating a business. There are other aspects to Title VII as well, but from what we're talking about today. And we've kind of set forth the bases of those prohibited discriminatory, of what's prohibited: race, color, religion, national origin, age, disability, sex and gender, and sexual orientation, and gender identity. We defend a lot of lawsuits, both in federal court and in state court, with respect to Title VII, and a lot of those arise from alleged sexual harassment. And just to be clear, sexual harassment is considered sex discrimination under both Title VII, and then Maddie's also set forth RC 4112. That's Ohio's anti-discrimination law, and in most respects, it mirrors the federal law, Title VII. The same categories are generally, folks are generally protected, and lawsuits, when they're brought under either of these statutes, proceed similarly, whether in federal court or in state court. Topically, I think one thing that's important for us that we've seen over the last few years is to note, with respect to harassment, that there's been a significant increase in allegations of same-sex harassment. And that obviously goes along with the United States Supreme Court having recognized gay and lesbian people as being protected by Title VII. There was a lot of controversy for a long time as to whether Title VII, where it prohibits discrimination because of sex, in fact prohibits discrimination because of sexual orientation. And for many years, the answer was no. Today, the answer is yes, unequivocally yes. In other words, a business may not discriminate against an individual because that individual is gay or lesbian or identifies as gay or lesbian, nor can the business discriminate against an individual who identifies with a particular gender, whether that's their birth gender or not. Transsexual folks are protected. And we have seen an increase, just anecdotally, we can share this, in incidents, both in retail clients and in white collar environments and in manufacturing, of same-sex harassment. I have seen it more, and I think this is just by chance, but in my own practice, and I don't know, Maddie, what you've seen, I've seen more female-on-female harassment allegations where you have really a very similar course of conduct that we see in male-female, more traditional harassment instances. You have a more dominant person with a crush who's pursuing someone and whose conduct, goes over the top. You see folks in management positions who are able to exert influence over someone that they also have an underlying kind of desire or hope to be with romantically. But that's something that we see. And finally, I'm old enough to have grown up with when, unfortunately, there was a real, almost casual prevalence of making small of people's sexual orientation. And for a lot of people, they need to be straightened down on that issue, because that which gives rise to lawsuits, the kind of what we call harassment, actionable misconduct, includes gay jokes. It includes making someone feel afraid or small because of their sexual orientation. We're not saying that from some, moral place. Folks have their own understanding of the world and what's right and what's wrong. We can tell you that that gives rise to serious legal jeopardy. And we do see that, and I think you'll see that across our profession as we talk today.
So, with Title VII and 4112, there is an administrative process that plaintiffs need to go through before they can reach the legal process and file a lawsuit. So Max is going to kind of go through, what does the life of harassment allegations look like, both at the administrative level and a lawsuit.
So I want to start by, and I think everybody's going to get a copy of, or at least have available a copy of the document that we're looking at. But one thing I forgot to put on here when we talked about remedies, and it's one of the more expensive remedies that can arise, is money that a jury may award for emotional damages. Because one of the things that happens in the course of sexual harassing misconduct is that people endure what we would call emotional or psychic injuries, and they have to see counselors and they have to see psychiatrists, and their course, the course of their lives is literally changed and damaged from that perspective. And I'll tell you, anecdotally, juries are inclined to punish a defendant amply for these kind of damages when they arise in a harassment context. It can be bad. So at any rate, the other thing, we should just briefly talk about, what the process looks like when litigation arises. But from a practical perspective, the overview should include pre-litigation, because oftentimes what people become aware of, there's trouble in the workplace. Something has happened. Somebody is complaining, I'm getting harassed. An underperformer has been terminated, and he or she says, you know what? I'm being terminated because I complained about harassment, or I'm being terminated by my harasser, or I am now making allegations of misconduct that I suffered in the workplace. I mean, a classic instance is a manufacturing shop where you hear a lot of racy conversation over lunch and breaks and stuff with, borderline jokes, and everybody thinks it's great and yucks it up about, various what'd you do over lunch with your boyfriend type of jokes. And nobody senses a problem until somebody's terminated. And I'll tell you, when people get fired, they very rarely look at that event and say, man, I could have done better. They often talk to a lawyer because they believe that they were wrongfully terminated for whatever reason. And the lawyer will go through a whole checklist of potential concerns, and this kind of stuff will come out. But at any rate, I don't want to digress too far, but first, you've got trouble, and somehow it wasn't appropriately dealt with. Maybe the company didn't know about it. Maybe it did and didn't handle it very well. Maybe the company knew and felt that the charges were baloney. But at any rate, oftentimes something has arisen. Now, either the individual still works there or they don't, but they file a complaint with either the Equal Employment Opportunity Commission at the federal level, which they can do, or at the state level, the Ohio Civil Rights Commission. And as a technical matter, they didn't used to need to do that before they filed at least a lawsuit in a state court in Ohio. Now, anyone who wants to file a claim of discrimination, whether it's under Ohio law or federal law, has to first go to one of these civil rights agencies, either the EEOC or the Ohio Civil Rights Commission. And there is another opportunity, potentially, for the defendant, the business, they're called a respondent in the EEOC, to resolve the matter, because the EEOC and the OCRC will always reach out and say, hey, do you want to sit down with one of our mediators and try and get rid of this? And it can usually be gotten rid of, settled, at a number that's going to be far less than what it takes to actually litigate the matter going downstream. Now, I will say that a lot of businesses, a lot of business owners, a lot of managers, a lot of responsible folks will raise their hand and say, no, we're not paying for something that didn't happen. We don't think this is true, and we're not going to reward somebody for making allegations against our business for something that we didn't do. And at some point, and oftentimes it's after they get their first bill, at some point, the business, kind of, the folks who operate the business kind of think to themselves, well, boy, we hate this, but what will it take to get rid of it? Or they won't. I mean, Maddie and I represent a very successful family business, still a family business, big, but it's a family business that will not settle a claim that they believe is wrongfully brought. Others will sit down and do almost an insurance company type of actuarial analysis and say, well, it makes sense at this number, et cetera. So at any rate, that's kind of part of that. If the EEOC and OCRC find that they're not going to take jurisdiction in the matter, that is, they'll look into it they'll say, we don't think that there's a reason for us to go further. They call that a no probable cause finding. Then the person who's made that filing can, if they want, file a complaint in a federal court or in a state court. And that's often what happens. In fact, a lot of times, people who have filed an EEOC complaint will file the complaint because the law requires that they do it, and then they'll call the EEOC and say, would you please dismiss my complaint because I really want to sue these guys, because there are more remedies available in court than there are at the EEOC.
And if I could just jump in really quick, from like a cost perspective, if the plaintiff does see the EEOC or OCRC process through in its entirety, the business would need to file what's called a position statement. And a position statement lays out, why that business feels that it did not discriminate against it. And, Max, you can tell me your experience too, but in mine, it seems that those position statements are costly. With our firm, I've seen them be anywhere from $5,000 to $8,000. And that's just at the administrative process level. You haven't even been sued yet. So that's something to keep in mind with regard to the costliness of this process.
Well, and also that's just the rights of thing.
Right.
At that point, your lawyers have spent a bunch of time investigating and understanding the claims and the charges. They've probably been out to the shop and talked to folks, and they've spent a bunch of time on the phone with whoever operates the business to really understand what's happened. So, yeah, from a business perspective, from a financial perspective, by the time you get that position statement filed, you've probably spent $15,000.
Yeah, that's a good point.
Really. And then the individual's either going to sue you or they're not going to sue you, or you've resolved it or you haven't resolved it. And if they file a lawsuit, I think it's helpful just to kind of click through this kind of quickly in terms of what a lawsuit looks like, because a lot of times, if you haven't been sued, you haven't gone through it. And so they file a complaint, and then you've got to file an answer. The business has to file an answer. That's a fairly mechanical process. Basically, you're admitting or denying the things that are said in the complaint, probably setting out some affirmative defenses. And then we enter into the process, the beloved process known as discovery.
It's like my least favorite part of being an attorney, discovery.
I don't mind it, but it's definitely, it's hard work, and from the business's perspective, it's expensive work. And it's not just expensive with respect to dollars, it's expensive with respect to focus and work on the defendant's part, because we're going to be answering a bunch of written questions, and more painfully, we're going to be producing a lot of documents. And we're going to probably be sitting for depositions. And that is when folks have to sit down, raise their right hand, promise to tell the truth, and answer questions from an obnoxious lawyer all day. And this stuff is. Go ahead.
Sorry. I just have a question. This is Marcia.
Hi.
So I see all the greatness of the liability that's carried here. How does a manufacturer even prepare for something like that? Is it an insurance policy that they would have to help them with litigating something like this, or is this money they need to have in the bank?
It's oftentimes businesses, manufacturers, or anybody else, it may have an employment policies, liabilities product. We call them EPLI policies. Employment policies and at any rate, EPLI, E-P-L-I. And oftentimes those policies will have very substantial deductible amounts, because it's just like any other insurance product. It's priced on risk, and risk is based on a variety of considerations, size of the business, and I'm not a broker, I shouldn't go too deep into that, but the other thing is the bigger the deductible, obviously, the cheaper the policy. So that's the easy answer. A lot of businesses do buy EPLI. They may own it just for the purposes of almost catastrophic recoveries by a plaintiff. We have a client that we work with that's got, I think, $250,000 deductible, and others have a much smaller deductible, and others feel like, you know what, I'm not going to buy the product because it's too expensive and I don't think I'll get sued. Otherwise, it's self-funded, and you know, if you get sued and there's a finding of liability against the business, then the business is going to be presented with a bill to pay.
And typically, those types of insurance policies cover cost of defense, so that's, you know, attorney fees that the business needs to pay to defend a lawsuit or an OCRC charge. And it also would likely cover a lot of the remedies if there was some sort of award against the business, or if the business decided to settle. But there are some things it's really important to keep in mind that those insurance policies typically don't cover. Punitive damages being one, attorney fees and costs being another. So that's just something to keep in mind, because those amounts can add up, and even if you do have those products, it's still a large cost to the business.
All right, so I don't want to chew up an inordinate amount of time on the litigation overview. You get through discovery, and then oftentimes the business will make an argument to the court that, listen, judge, here's the evidence, here's the law, and you ought to dismiss this lawsuit. And I would say even maybe a majority of harassment lawsuits are in fact dismissed under that process that we call summary judgment. It's expensive. It takes a lot of work. Moving, as we call it, moving for summary judgment is one of the real heavy lifts for a lawyer. It requires a very careful recitation of the facts and application of the law, and all the work that you've done is kind of reflected in that document. You can't really so much as, say what time it is without supporting it with some extrinsic evidence. And then if you're not successful there, and if you still haven't resolved it, you're going to go to trial. And that is probably the most demanding thing that lawyers do. And it's probably the most expensive thing that lawyers do. And by the time you finish trial in a garden variety sexual harassment set of allegations, and let's say you get a defense verdict, you've probably spent $150,000 easily. Yep. And that's kind of low average-ish. And we're not trying to dwell on money, but I think, again, we're counselors. We're trying to keep you out of court. We're also trying to apprise you of the risk of going to court. Yeah. And I think that's probably among the more valuable things that we're able to offer to a business. I would say any lawyer would hold themselves out as being able to offer to a business.
And I know that we talked a lot about Title VII and then the Ohio statute 4112. I think that it's also important to note that different states have different rules. So if your manufacturing company has different locations in different states, it's really important to make sure that you're in compliance with all of those different rules. So Ohio-wide, there's been a couple of changes recently. And actually, the Forced Arbitration of Sexual Assault and Sexual Harassment Act is a federal law. But specifically, one of the biggest things to happen in Ohio recently was the Ohio Uniform Employment Act. I'm sure if you guys are HR professionals on the call, you've heard about it. It was effective April of 2021, so we've almost had it for a year now. And one of the main things that it did was it streamlined a 2-year statute of limitations, which is significant. And a statute of limitations limits the amount of time that a plaintiff can bring their claim against a business. It significantly chopped it. It used to be 6 years. So that's actually kind of a good thing for businesses. It also, as Max mentioned earlier, required that folks, before filing a state action, go see the Ohio Civil Rights Commission and file a charge with them. You used to be able to go straight to state court in Ohio. You can't do that anymore. And it also significantly limited liability for supervisors. So HR folks and supervisors used to fall under the definition of employer under 4112, and it edited that definition so that those folks can't be sued individually unless there's some real individualized action. action on their part, not just as an agent of the company. So that's probably also a positive thing for a lot of you on the call. The Ending Forced Arbitration of Sexual Assault Act, Biden signed this into law really recently, March 3rd of this year, and it basically limits the use of arbitration clauses in sexual harassment cases. So persons alleging sexual assault or sexual harassment can't be forced into arbitration, and they have to have the option of a public forum, which would be a lawsuit. It kind of goes to the state of sexual harassment in our culture today and shining light on misconduct. We don't want companies to be able to sweep things under the rug and kind of hide issues of misconduct. We saw, I think that definitely happened with Weinstein and Matt Lauer. So this is one step federally that they're taking, but it's a challenge for businesses. That means that you can easily be named on a public docket. So that's something to keep in mind. I'm gonna kind of keep it moving because I know we're running a little bit short on time. So let's talk about the different types of sex discrimination under federal law or Ohio. So just traditional sex discrimination is harassment or unequal treatment based on the sex of a person. So some examples are this is a classic, male being treated more favorably than a female. Male gets a promotion that a female was more qualified for simply because he is a male, and the hiring manager wanted another male to be in that role. How Max mentioned earlier, we have a lot of issues of sexual orientation and gender identity discrimination. Now, since the Bostic case, that was the case that he mentioned, Bostic versus Clayton County, that was in 2020. The U.S. Supreme Court held that sexual orientation and gender identity are encompassed in the term sex under Title VII, and that extended protection to gay and transgender employees. So you could also have the example of a heterosexual individually treated more favorably than a homosexual individual or a transgender individual. So that is another example of just traditional sex discrimination. A second type of sex discrimination that we see, this is maybe the most prominent one that we see, hostile work environment. So this is unwelcome conduct on the basis of sex, and it does have to be severe and pervasive enough that it's actually impacting the terms and conditions of someone's employment. And this is a common misconception. It does not actually need to be motivated by sexual desire. So one example that I thought of there would be a heterosexual male making inappropriate sexual jokes about another heterosexual male's life. That can definitely create a hostile work environment. So, you know, I think that more commonly we do see that it is motivated by sexual desire, but there's case law out there that it does not have to be. Examples of hostile work environment or actions that can lead to a hostile work environment. And it's important to walk through these because some of them may seem innocent, and they're not in today's day and age. And it's really important for folks to educate their employees on what's appropriate and what's not. So some examples, repeated propositions and repeated requests for dates. You know, I noticed you didn't answer my email to get drinks. Like, can we please go for drinks? Like multiple requests so that it starts to become oppressive.
We just had a senior executive about 2-3 years ago who's lost his career. The business got crushed in an expensive litigation. It was eventually settled, but it was expensive. And it was exactly what Maddie's talking about. The guy, age probably 50 years old, had fallen in love with an employee who also reported to him, and the whole, you know, repeating propositions, the request for, you know, being together, creepy emails, creepy notes, creepy gifts, you know, that maybe 30 years ago you'd roll your eyes at it and say, buddy, grow up. It ended up in a very damaging legal action.
Yeah, it's just with coworkers, you're always going to have some sort of interactions, but it's really being a safe workplace where folks feel like they're not targeted and like they don't have to feel uncomfortable at work because, you know, he's making. I mean, some other examples: flirting, jokes of a sexual nature, remarks about a person's appearance. Somebody constantly saying, "Oh, I like your hair," like, they're doing that every day. They're commenting on, "Oh, I like that you're wearing a skirt today." It's just inappropriate.
But we need to say too, I think,
Mm-hmm.
we're not trying to change human nature.
Right.
We understand that men and women work together and interact together in a natural, but we have to say more closely viewed, appropriate way.
Right.
And you just have to have that sense. And I think, and I don't mean to jump ahead of us, but the most important way to discern what's appropriate and not appropriate is to make sure that your employees feel that if they are inappropriately approached, they've got some place to go talk about it.
Exactly.
And to get the situation addressed. We can't suck the humanity out of the workplace,
right.
But we can make it safe, and we can make it such that people feel safe in working there, and they've got, they know that they've got someone that'll listen.
And you have kind of things that maybe we do naturally, touching. Maybe you have somebody repeatedly touching on the shoulder. It can become too much. But like Max said, it's important where if somebody starts to feel uncomfortable about something like that, they know who to go to. Staring. We've recently, it's kind of immature when you think about it like that, but somebody staring at you from across the room. But we recently just dealt with a lawsuit where somebody was staring menacingly in a lunchroom.
Yep.
So it's definitely a thing. Unwanted gifts. Max is going to tell you a story about a Hershey Kiss in a little bit that was definitely an unwanted gift. Pictures of a sexual nature, showing somebody, pictures of themselves in a swimsuit, or maybe, pictures without a shirt or something like that. It's just inappropriate.
And can we just say no to pornography?
Yes. Let's just not do that at the workplace.
Yeah.
I mean, come on now.
Don't ever hit send.
Yeah.
I don't mean to instruct people on the line. I know you would never do that, but
right.
I mean, that's a really huge issue.
And obviously sexting and inappropriate emails. I mean, you would be surprised what folks write on company email and what they send. So, kind of use common sense there. The third type of kind of sex discrimination is quid pro quo, and Max mentioned this earlier. It literally means this for that. If you do this, you will get that. We see this a lot, and it's a big issue with supervisors and direct reports. So kind of the example that Max gave earlier. You have the exec and assistant relationship, or partner and associate relationship. So it's somebody that is a gatekeeper and controls the destiny, maybe controls your salary, and also maybe evaluates you. So they're really controlling your destiny. And a lot of times the power dynamic makes it such that either an individual feels like they can't say no if there is an advance made, or they feel like, or maybe it's explicitly said that if they give in to the advance, they will get advance in their career. So it's important to point out that the definition is that the difference between welcome and voluntary. So technically the conduct must be unwelcome, but that does not mean just voluntary. So you don't need to have a sexual assault situation to have conduct be unwelcome. So an example, a female subordinate willingly kisses a male boss because he promises a bonus. That's a classic quid pro quo example where, he didn't assault her to kiss him, but it's still inappropriate conduct and actionable sexual harassment under quid pro quo theory.
A boyfriend-girlfriend relationship that does not necessarily involve forcible sexual conduct. It may involve consensual sexual conduct.
Yep.
Can still be coercive.
Mm-hmm.
It can still be, you do this, you get that.
Right. Marcia,
do you have one question that came from the group?
Sure.
Okay. Brianna asks, are there any cases you've dealt with where someone is accused of harassment but didn't realize that their gestures were unwelcome?
Yeah, I mean, that's pretty common. I can't think of any specifically offhand, but I definitely think that because there is such a fine line, maybe somebody is just kind of a touchy-feely person and is touching somebody on the shoulder, and they're not doing it in any sort of sexual way or for that purpose, but it's making the person uncomfortable. I mean, that's one example that I
I
can think
had,
of.
and this is a manufacturer, you know, a shop floor situation. I believe this person. They were a supervisor who, you know, there had been a lot of like kind of dirty jokes. I don't know how else to say it, you
Yeah.
know, and it was kind of everybody felt comfortable. And I think that this person legitimately had no sense that he was doing anything that would cause anybody to feel afraid or otherwise harassed. And so the answer is yes, in my experience. Oftentimes, the quote harasser isn't intentionally harassing anybody. The conduct, you know, was perceived as offensive, but he certainly or she certainly didn't intend it to be that way. We just had one the other day with a retailer. Again, this was a woman on woman situation. And the woman who was accused of inappropriate conduct had no idea, or at least she certainly alleged that she had no idea, and I could see where maybe she didn't. That her comments for her female colleague regarding appearance and maybe a little on the racy side would be taken as offensive. I don't know if that's answering the question.
Yeah, and a lot of times that's where like training and, having a really strong relationship with a counselor that you can trust comes in, because you really, as an employer, need to educate that person why that conduct was inappropriate. And you need to have processes in place to deal with that on a consistent basis. And Max is going to talk a little bit about that. Have about 7 minutes left.
Yeah,
So you can kind of go through, Max has some strategies to reducing risk and establishing processes to help keep you out of litigation, and also some fun case studies.
Yeah, maybe we should do the reducing risk first, just because maybe that's the most important thing that we can share.
Mm-hmm.
First of all, and it's not written as well on here as I'd like to be. I just as an overarching proposition, take it seriously. If the most common thing that I think Maddie will agree, and we've done some cases together, where the issue arises, the harassment issue turns into something toxic and big because the company didn't take it seriously, as it was evolving. We just finished a matter where there was this ongoing course of conduct by someone, with respect to a colleague, and that individual, the recipient of that conduct, complained a lot, and it wasn't taken seriously. And it ended in once the lawyers are involved, obviously it's an issue, and it was expensive, and it was drawn out, and it was damaging to that particular unit of that business. So take it seriously. We have on here, and part of taking it seriously is ensuring that people have the ability to report. So we say ensure safe reporting, establishing a reporting process. That should be set out in a handbook, but also I think an organization of any size at least ought to have annual conversations at minimum about this topic and about other employment topics as well. Obviously, we deal with a range of issues, but ensuring that employees know where and how to report a problem, and that no employee ever feels trapped or ignored or afraid because they can't get relief. That's not only wrong, but it's expensive. Preventing retaliation is obviously a part of this. Sometimes, maybe most oftentimes, the person who believes they're being harassed has been harassed by a supervisor. That's a big deal, or someone close to the top of the organization. This has to be taken seriously, that people feel safe in reporting harassment. And we have, specific, remedies for that in terms of we always write that into a handbook or write it into various documents that employees will review and understand what the process is. And by the way, when you get sued, if the company legitimately has such a process in place and the employee doesn't take advantage of it, that is a complete defense, or it can be a complete defense to liability.
Yep.
So that's not just, commonsensical advice, it's legal advice. Employee handbooks are important. We think that we draft those with a lot of care and with a lot of focus on the employer. And I'm not a huge fan of off-the-shelf handbooks. I think that they should be crafted to that particular workplace.
It's always an exhibit at deposition. Always. The HR person's being deposed, they're asked about the policy that, the employee supposedly violated.
Yeah.
It's always in the handbook. So, that may be scrutinized by a fact finder in litigation. So it's important to make sure it's really thorough.
And I guess in the interest of time, we don't have to go through all of these, but training is important.
Yeah.
Harassment training is important. It's not only important, again, commonsensically preventing harassment, but in the world that Maddie and I sometimes find ourselves in when we're not counseling, but rather we're litigating, it's relevant in terms of liability. So consistent and fair investigations, I think that should speak for itself, but it's got to be real. It's got to be defensible. If somebody comes to you with an allegation of impropriety, of improper conduct, of their suffering harassment, or whatever the issue may be in the workplace, third party will later ask, what did you do about it? The quality of the investigation, it doesn't have to be expensive. It doesn't have to be extraordinarily complex. It doesn't have to be anything except somebody would ask later, commonsensically, were you trying to get to the root of the problem? Was the investigation properly fitted to the allegation?
And documented. One thing that I've seen really recently is just lazy documentation. I mean, not writing out the facts of what happened, the facts or the allegation, not giving documents to people that you're supposed to be giving them to. I'm involved in a matter right now where an ADA request was never addressed and not given to the person that requested relief. So, we're looking to settle that. So, documentation is an issue.
I want to, because I think we're nearing maybe the end of our time, and we don't want to be disrespectful about folks' time. We talked about we were going to share some stories. We don't do that just because we like to hear ourselves talk. At least in some of these instances, they do kind of reflect on best practices. So I just want to jump to one story, and I'll be brief. And it's really a tragic story because a woman who did not speak English was working third shift for a business as a cleaner, as a commercial cleaner. And the one individual on those crews who did speak her language was also her supervisor. And over time, he undertook a course of conduct that began with what we would call harassing language, suggestive, and she became increasingly concerned, and that language became stronger, and it became touching, and finally, in the end, this ended with him raping this woman. And I dealt with this case relatively early in my career, and interacting with her, and I was actually working on her behalf. She was ruined. It was crushing, it was tragic, and it was avoidable. This woman had no lifeline. This woman was in buildings overnight with the man who would be her rapist, and she had no one to ask for help, and she was completely vulnerable. And when she brought the allegation after it happened, they didn't believe her. And they dismissed her allegations because they liked the guy who was her supervisor. I guess the point of that story is not to be, dramatic over human tragedy, but to, again, highlight the fact that businesses need to ensure that employees have a safe and real pathway to relief if they are being subject to this kind of behavior. And I don't mean just physical assault. Obviously, we're talking about harassment generally. She didn't have that pathway. And this was ruinous, both with respect to her own life, but with respect to the business. The business closed, and it was, and so that's that. I think we're probably approaching the end, and we don't want to
Yeah.
hold people up. So, Maddie, I'll let you take over.
Yeah, we're out of time at this point, but we really appreciate you guys listening to us today, and hopefully we added some value for your guys' positions and businesses. Both of our emails are on there. If you have questions, feel free to reach out to us. We're happy to expand on the topics discussed today, or really any area of employment law that you have questions about.
Yeah, if you got a question, shoot us an email. We'll answer it, or as best we can.
Well, thanks you guys so much. Thank you everyone for joining us on the call today. And thanks again to Maddie and Max for their excellent presentation. Everything that has gone on today will be recorded and will be available on our YouTube channel. And if you do have any thoughts of other presentations that you might like to see from Manufacturing Works in the future, feel free to reach out to any of us, and we'll do our best to make that happen. And this presentation today happened because we do have a few of our manufacturing members that were inquiring about sexual harassment and how to present it and prevent it at their workplace. So thank you very much, Maddie, Max, thank you. And we'll see you in session 2 in a couple weeks. Thanks very much.
Thanks for having us.
Thank you. Bye-bye.